I'm holding in my hand the most curious and disturbing document that I received yesterday from Florida Default Law Group. It is a notice of withdrawal of an affidavit of amounts due and owing that was filed in a case. The thing that's most staggering about this document is in it the law firm, Florida Default Law, indicates that the affidavit of amounts due and owing that was previously submitted in this case apparently was verified or executed improperly. In a limited case, people would make mistakes, and in limited circumstances, one could overlook mistakes such as that. However, the information that I'm receiving is that many, perhaps thousands of these notices of withdrawal of affidavits have been sent out across the state. And the thing that's most compelling about this is the affidavit that was filed in this case, and which is presumably trying to be withdrawn here, was executed by Stephan, S-T-E-P-H-A-N. The deposition transcript that's posted immediately below this blog input indicates that Mr. Stephan was executing more than 18,000 affidavits of amounts due and owing a day, and that deposition clearly indicates some of the problems with that. This particular affidavit of amounts due and owing was submitted to the court on March 11th, 2009. And the question that I have, the question that's presented by this unprecedented step of withdrawing these affidavits is, if the law firm now is in the pleading asserting that the affidavits have been submitted, are improper and now need to be withdrawn, what happens to all of the thousands, perhaps tens of thousands of cases that were decided, summary judgment or otherwise, based on affidavits that they are now admitting were improper and false? The question becomes, does it rise to the level of fraudulent information such that the judgment is void and can always be overtaken, or is it merely voidable and you've got a 1-year opportunity to have the judgment vacated? Whatever the case, it's a stunning development. Again, re-emphasizes the point that I've made again and again, and that many attorneys from across the state and advocates across the state and country have made, is that something is terribly wrong in this foreclosure process. When we have one of the large volume foreclosure mills submitting documents that are apparently improper across the state, and frankly this isn't a surprise, we've all been screaming about this for months and years now, but the fact that all of these firms are engaging in such a rapid process is complicated now by the fact that the courts are adopting these foreclosure rocket dockets. If anything, what the investigations of the Florida Attorney General and the developments such as this represent is the fact that we don't need rocket dockets. We need to slow down these dockets dramatically. We need to have a careful examination of every single file before summary judgment is entered. And frankly, I don't see how in good faith and good conscience the court can grant summary judgment in any of these cases, given the widespread nature of the investigations of the Florida Attorney General's office and others, and what we can see on the face of documents being questionable. I frankly think it's irresponsible for our courts to grant summary judgments and to give these law firms the benefit of a shortcut procedure when, as indicated by this attached affidavit, those procedures have been grossly abused. I encourage all of you to scour your files, and any time you see an affidavit of Stephan, object to that, and let's wait and see the true circumstances behind this unprecedented withdrawal. For those of you consumer activists out there, I'd go back to all of your files and see, even if a judgment's been entered, if it's been entered based on an affidavit signed by one Stephan, you might have grounds to have that judgment vacated and force the law firm and the lender to start all over again with that foreclosure. Keep the fight up.